order that they were published. So we'll start off with House Bill 2372. Mr. Paul.
Mr. Chair and members, House Bill 2372 repeals the state's agricultural nuisance law and replaces it with a new one that would limit nuisance actions against agricultural operations on farmlands to instances in which the plaintiff is the sole possessor of real property, the real property is within half mile of the alleged nuisance, and the action is brought within a year of the agricultural operations establishment. It establishes a rebuttable presumption that an agricultural operation is not a public or private nuisance. This presumption exists even if the operation changes ownership or size, ceases operations, uses new technology, or participates in a government-sponsored agricultural program. This presumption can be overcome by preponderance of evidence if the operation is violating applicable federal, state, or local laws and regulations. This bill also outlines how a court should award costs and damages, and in a case, this bill also outlines how a court should award costs and expenses, and when a nuisance is found to exist, different types of damages. If enacted, this law would supersede any municipal ordinance that makes these operations a nuisance or provides for an operation to be abated as a nuisance. And with that, I'd be happy to answer any questions.
Question for staff. Yes, sir, Representative Rodriguez.
Thank you, Mr. Chair. Paul, are there any other bills that you're aware of that have the geographic type of radius that we're talking about in this bill?
Mr. Chair, Representative Rodriguez, I'm not aware of any bills that have a geographic limitation such as this bill, but I can look into this and get back to you.
Thank you. Mr. Chair, Paul, are there, if I heard you correctly, could you just confirm that it says that the claim must be brought within 1 year of establishment of the operation?
Mr. Chair, Representative Rodriguez, that's correct.
And so it is, and Mr. Chair, Paul, so that decouples it from when the harm is discovered by the person?
Mr. Chair, Representative Rodriguez, can you clarify your question, please?
Sure. Normally, a person has their right to seek redress in the courts arises when they've been harmed.
Mm-hmm.
This seems to say that everyone will be tied to the 1 year of establishment, within 1 year of the establishment of the operation.
Mr. Chair, Representative Rodriguez, I think that's broadly correct. I am thinking, though, of... Can we turn this microphone down slightly? Mr. Chair, Representative Rodriguez, I think that's broadly correct. I think the issue would be whether someone could overcome the rebuttable presumption based on a violation of state or federal law.
Thank you. And then, Mr. Chair, Paul, regarding the rebuttable presumption, is there another statute that you're aware of that ties a person's right to seek redress to overcoming a rebuttable presumption in federal law?
Mr. Chair, Representative Rodriguez, I'm not aware of any, but I can look into that as well as your first request as well.
Thank you. I have nothing else.
Thank you. Any other questions? Representative Cook.
Thank you, Mr. Chairman. Paul, when I read this, it has to do with the operation going into existence. What would happen if the operation was in existence and then 1 year, 2 years, 10 years later down the road, they went in and they did an expansion or changed what they were operating? Would that disallow a suit to be brought because it was in existence for over that time period, or would it start when the change or the expansion would happen?
Mr. Chair, Representative Cook, if I'm reading the bill correctly, the rebuttable presumption would exist even if there was a change in the size of the operation or the type of product that was produced by the operation. If it went from being, say, a cotton farm to a facility that houses stock or swine, that the clock would still exist at the point of that operations establishment, regardless of those changes in size and the nature of the product produced.
Thank you.
Any other questions for staff? All right. Thank you, Paul. All right. As a sponsor of this bill, what we're really narrowly focusing on is frivolous lawsuits. It's not focused on something that's violation of state or county laws. It's about the frivolous lawsuits that come about because for nuisance. And so that's what's narrowly crafted for. We've been working with stakeholders, have been working with meetings the last several weeks. That's why we've been holding the mill until today. We're still working on an amendment that would come forth. For sure we know we're going to take off the 1 year. There's consensus we need to take off the 1 year, the 1 year clause that needs to come off. We're working on getting some constitutionality from Ledge Council on some of the other limits of claim liability as to where that's at. And so we'll have some people here to present why this is the need for agriculture, and it's a work in progress. The mirror bill to this is in the Senate. It's stopped in rules, and so we'll see where this bill goes, and with the testimony here. But with that, I'll answer any questions, or we'll wait till after testimony. All right, swallow first.
Mr. Chair, I guess we'll start with people in the room in the order they are on my list here. We have Barry Aarons.
Good afternoon, Mr. Chairman, members of the committee. For the record, my name is Barry Aarons. I'm here on behalf of the Arizona Trial Lawyers Association. We are opposed to the bill. There have been a couple of questions that have come up, which I think demonstrate why we have concerns with this bill. I appreciate, Mr. Dunn, that you have had some conversations with us. We are disappointed that we, despite offering, have not been invited to any of the stakeholder meetings or whatever those meetings looked like. But Mr. Dunn, I appreciate your conversations, and I also conferred with your counterpart in the Senate, Ms. Kerr, when this bill came up over in the Senate last week. I have 4 points I want to make. First, with regard to frivolous lawsuit, it's easy to throw around the term frivolous lawsuit. There are court rules, as I think Mr. Rodriguez would suggest, I think as Ms. Blackwater-Nygren would suggest, that clearly deal with a legitimately frivolous lawsuit. So I would suggest to you that if there are frivolous lawsuits being filed at the present time, that they are probably controlled under those rules, under those court rules, and could probably be dealt with like that. Having said that, I'm happy to hear that, Mr. Chair, you're going to do away with that 1 year limitation, because that is the most egregious thing I think we've ever seen. Because what happens is that provision could mean that the time limitation expires before the act occurs. And of course, that's something we certainly don't wish to do. So I'm pleased to hear, Mr. Chairman, that you're going to take that out. Secondly, with regard to rebuttable presumption, Mr. Chairman, Mr. Rodriguez, I think you raised the question, is there any such rebuttable presumption that Arizona state law can do with regard to federal law? We're not aware of any. I think that's why you raised the question, Mr. Rodriguez, and we would concur with that. So we think you have a problem with that. Third item is the punitive damages. We're on line 5 of page 2 of the bill. We see that as clearly an unconstitutional provision. The legislature cannot, under existing constitutional provisions, say you cannot award punitive damages as a fait accompli by law. We think you need to deal with that. When we talked, Mr. Dunn, I got the impression that we were looking at maybe pulling that out. And if you are, that certainly would address that problem. Last thing is, and I'm not here on behalf of a city, but I will tell you that whoever crafted that preemption language on paragraph F, it's the most magnificent preemption I've ever seen drafted in my 51 years in this business. I got to tell you, and I think that's of concern, because I don't think, especially if I were in rural Arizona, I don't think I would really appreciate the fact that my local government would be superseded by the state with regard to ordinances and control over certain types and definitions of nuisances. So we would suggest also that that is rather restrictive, and that would be a problem also. Again, Mr. Chairman, thank you for your willingness to chat with us about the bill. We appreciate that. We would ask the other stakeholders who are probably in the room, who at least I saw on Zoom at the Senate hearing last week, that we stand ready to sit with them and help craft amendments. But having not seen any of the amendments or any of the proposals, unfortunately, we still have to stand in opposition to the bill. With that, Mr. Chairman, I would be happy to entertain questions.
Representative Rodriguez.
Thank you. Mr. Chair, Mr. Aarons, could you please Did your organization do a survey to determine what cases of this type are currently in the court system?
Mr. Chair, Mr. Rodriguez, no, we didn't look at the great number. We do know there is one case that has been extremely controversial, but because it is currently being litigated, I'm not at liberty to discuss it.
Do you know who the, Mr. Chair, Mr. Aaron, do you know who the parties to that lawsuit are?
All I can tell you is that my attorney is Nick Verderame, who talked to one of the agricultural stakeholders on this bill last week, Wade Noble. I think you all know Wade, and it is a suit against Hickman Farms.
Thank you. Mr. Chair, Mr. Aaron's, let's talk about the half-mile radius. It seems to me like if you take a circle from the center of the operation, which I'm assuming that's how we're going to determine where it's at, and then you do a half-mile radius around it, that you could literally be cutting subdivisions in half if there was a subdivision or other landowners who were located there.
Yeah.
Is that a scenario that is possible under this bill as currently written?
Mr. Chair, Mr. Rodriguez, I think there are several, because the language is very loosely written, I think there are several circumstances that could determine the half mile. And it could be a half mile from the extremities, it could be a half mile from the center, or it could be a little bit of both. And I think that's the problem with some of the way that the language is written. And I think that, you know, over time, you're going to see that half mile be more and more. But more than that, Mr. Chair, Mr. Rodriguez, if you have two different types of agricultural production going on that are next to each other, for example, you could have a low nuisance produce, the growing of lettuce, growing of celery, carrots, the general melons, that generally are not considered produce. And then next to it, you have an agricultural production that deals in certain elements of livestock. Nuisance isn't just, oh, that smells bad. Nuisance could be the fecal matter of the livestock seeping into the soil, contaminating the produce, and then making it not qualified under FDA regulations for transport to other states. And as you folks well know, I know Mr. Dunn and Mr. John know this, Yuma exports, I think, 80%. Is that correct, Mr. Dunn? 80% of all the produce in the United States and Canada comes from Yuma, Arizona, which is something we should be proud of, and we would rather not hamstring those produce carriers to be told you can never file a nuisance lawsuit because we're going to put these very, very strict controls down on it. Again, there are a couple of amendments Mr. Dunn has talked about which we think would give a modicum of relief, but I still think there's other problems in it, and quite frankly, we would suggest to you that the existing nuisance law works quite well.
Thank you, sir.
Any more questions?
Thank you, Mr. Chairman. I'll be here the rest of the bill consideration if there are any other questions for me.
Thank you for being here.
Mr. Chairman, do we have a Daniel Blackson in the room?
Mr. Chair and members of the committee, I am Dan Blackson. I live in the Tonopah community. I'm here because our community stinks. The malodor is obnoxious, offensive, and objectionable. We're plagued with flies. We swat flies inside of our house from morning to night. I live just over a mile from a concentrated animal feeding operation, or CAFO, is 4.5 million chickens. And that's what this bill is really about. Not about fields, alfalfa, cotton. It's really about CAFOs. CAFOs are dairies, hog farms, feeding lots, egg ranches, and the sort. In other words, they're industrial animal factories. I'm a Republican. I'm a precinct committeeman, a state committeeman. I was a chairman that organized LD 13, and I am concerned that this bill does not represent the values of the Republican Party. Limited government, less regulation, individual freedom, law and order, one justice system for everyone, and fair capitalism. Like other Republicans, I want clean water, I want clean air, I want clean land. I'm concerned that this bill does not measure up to those values. It imposes new regulation that limit the ability of citizens to exercise their rights, to insist on the freedom to enjoy their property. It's probably contrary to the the Arizona Constitution by eliminating and limiting the right of people to sue for damages and injuries. Nuisance litigation stands as one of the few legal tools available to rural communities that are aggrieved. This bill takes away the ability to enjoy our property and gives CAFOs a right to harm and pollute our community. Basic rights of free use and enjoyment of property stand as one of the few remaining avenues for rural Americans to control the nature of their communities. HB 2372 takes away those basic rights and empowers CAFOs to be nuisances. Government has not always treated our community very fairly, and I'd like to go through some examples. There are many laws that should protect me, but regulations and courts choose not to. The Clean Air Act does not exempt CAFOs. Neither does Arizona Revised Statutes, Arizona Administrative Code, or Maricopa County Air Quality Rules. The agencies and boards ignore and interpret the law to allow CAFOs to violate the law, do not protect the health and well-being of citizens, or protect the environment. And here's some examples that we have experienced. For example, the CAFO near me operated without a permit despite complaints. Maricopa County didn't inspect the CAFO until after the permit was issued, and then did not issue a violation for operating without a permit. These are the type of things that happen after you enact your laws. For example, I challenged the CAFO air operating permit, and the Air Pollution Hearing Board ignored the CAFO's production of volatile organic compounds above the Title V air quality permit limits. For example, there's a complaint against the CAFO for operating a rotary dryer without a permit. What happened then was ADQ came back and they changed the rules weeks, if not months later, to allow that rotary air dryer to operate as a best management practice. And perhaps maybe the worst of all is Maricopa County Air Quality Department decided to change Rule 320, odors and gaseous air emissions, to remove the regulations on odors. Fortunately, the County Health Board stopped that, and it did not proceed, but what the agency did was take that stipulation out of all of the operating permits. So there's no longer an odor standard. Government is unwilling to enforce existing regulations for CAFOs, but more than willing to create new regulations to protect agriculture nuisances instead of protecting people and protecting the environment. Today, you're doubling down and trampling on the laws that protect rural American citizens. The Tonopah community has suffered from the pollution of an egg factory, and now instead of removing loopholes and improving regulations, this bill provides protection to the nuisance. Regarding fair capitalism, the pollution from one business should not cause another business to shut down, to close. A CAFO more than a mile away, the Saddle Mountain RV Park, a CAFO more than a mile away from the Saddle Mountain RV Park caused it to close its doors because of odor, flies, and chicken dander. Yes, raw pollution is continually released into the air by this CAFO. It's spewing particles, particulate matter near the Clean Air Act Title V permit limit. It's spewing volatile organic compounds above the Title V permit limit of 100 tons per year. It spews out extremely hazardous substance, ammonia concentrations. It also, in that pollution, air pollution, there are endotoxins, pathogens, chicken feces particles, bacteria, and many more harmful chemicals. And there's a study titled Speciation of Volatile Organic Compounds from Poultry Production that you could see the entire list. It's quite long. I'm here today because I've been held hostage in my home by 4.5 million chickens. Now that might put a little smile on your face and you might think of a Gary Larson cartoon of chickens outside your home with pitchforks and shovels and things. But sadly, it's true. The air outside my home at times is not breathable. It waters your eyes, makes your nose run, burns your respiratory system, and can make you feel sick to your stomach. I'm here today because I've not been able to enjoy my property. By placing a limit 1/2 mile on the source of agriculture operation, the CAFO, and its admission that the source is a nuisance, the opposite should be done, and the bill should focus on the well-being of people, not the profit of animal production. It should limit agricultural operations, especially CAFOs, from being built anywhere near an affected property, a dwelling, a business, a school, a church. Life in rural America matters. ADQ requires setbacks for sewage treatment facilities. Why not for CAFOs? I apologize, let me skip. I guess I'm running along. April 2002, City of Glendale passed the ordinance 2253, declared emergency, condemn and take immediate possession of hog farm and egg farm. The ordinance states the immediate operation of the provisions of this ordinance necessary for the preservation of public peace, health, and safety of the City of Glendale. Emergency is hereby declared to exist. Lives in rural America matter just like in cities. People should not be expected to tolerate nuisance under any condition. A non-agricultural related nuisance, or if a non-agricultural related nuisance source was in your neighborhood, would you give them the same protection? You have an oath sworn to the people of the United States, not the animals. Remember, not one of those 4.5 million chickens in that CAFO near my home ever voted for you. Vote in favor of human beings in rural America. Vote no on this bill. Thank you.
Any questions? Mr. Rodriguez?
Thank you. Mr. Blackson, thank you for coming here today.
Welcome.
A couple of things that you mentioned during your statement. We've heard the term frivolous lawsuits used, and I think it's just a term that people just tend to use in a knee-jerk form right now. Talk to me a little bit about when you saw this bill and you heard it was to address frivolous lawsuits. What was your reaction?
This is the first I've heard that it was meant to address frivolous lawsuits. But to me, when you cannot enjoy your property, it's not frivolous. When you can't go outside and walk or exercise or do landscape, or on these beautiful Arizona mornings we're having right now, sit and have a cup of coffee, that's not frivolous. I retired to be able to do those things, and I can't.
Thank you, Mr. Chair, Mr. Blackson. One of the, when I was in law school, I got to be honest, I didn't really enjoy property. That was a class I did not enjoy. But one of the first things they taught us was that going back to the English common law, that one of the basic foundational premises of property law is to ensure the quiet enjoyment of property by the owner. And so it seems to me you're coming here today to stand up for the individual's right to do so and have no ill will towards any particular person or corporation. Is that right?
No, I do not. I just want to enjoy my property, and I want my neighbors to be able to do the same. And I just want whatever the nuisance is to be responsible and do their best to abate it and stop it.
Thank you. Mr. Blackson, Mr. Chair, you mentioned the term fair capitalism. Now, that means different things to different people, but would you agree that fair capitalism includes good corporate citizenship, that corporations are allowed the opportunity to gain profits, but they should be good citizens in the course of doing that?
I totally agree with that.
Thank you. And then you mentioned the radius issue. How far is your property from?
It's over a mile.
It's over a mile.
Yeah. It's maybe a mile and a tenth, and that's from boundary to boundary. That's not to the hen houses.
Mr. Chair, Mr. Blackson, thank you for stating that on the record. Finally, you mentioned the use that Glendale had resorted to the use of an emergency nuisance declaration in order to address this type of situation. Could you speak to that? Do you approve of it? Were you just stating that as a fact, or did you see that as a point of advocacy?
I see it as a point of advocacy because whether a nuisance is in a city or whether it's in a rural area, it really should be addressed. And in this case, the nuisance existed in Glendale for quite some time, and then they declared this emergency. But for us, the nuisance moved right near the center of our commerce and literally right next to dwellings.
Thank you. Thank you, sir.
Any other questions? We appreciate you being here. Thank you for your testimony.
Mr. Dunn, thank you very much.
Next, we have Chelsea Mcguire.
Thank you, Mr. Chairman and members. For the record, my name is Chelsea Mcguire. I am here representing the Arizona Farm Bureau here in support of House Bill 2372. I believe that staff and Mr. Dunn did a great job of explaining the bill, and just want to hit some of the highlights, and then I'm happy to answer any questions from the committee itself. First of all, this bill is because we support responsible actions that are designed to allow and protect the privileges and the rights of farmers and ranchers to produce and market their product. We support actions that ensure farmers are protected from undue liability and nuisance suits while they carry out normal production practices. This is not meant to bar all nuisance claims. This is meant to bar those claims that are indeed frivolous, that word that we've been throwing around. Claims by plaintiffs that are located so far away from an operation that it is unreasonable to believe that they're impacted by it. That's the purpose of that geographical limitation. Again, as Mr. Dunn explained, there are some changes that we're looking at, some amendment language that we're considering within that bill, hoping to make sure that we can get everybody on board with that. This is also a bill that is meant to basically codify the already existing common law doctrine of that coming to the nuisance. So what that means is that if there was an existing operation and the impacted party moved to that operation, that impacted party essentially was on notice of what they were moving to. And that is a common law doctrine that's been set out in case law before. That's the purpose of that 1 year limitation. So the idea is that if the agricultural operation has been in progress, has been in operation for greater than a year, a claimant that had moved to that operation should know that that operation exists and know that that risk of liability or that risk of nuisance is there. That's the purpose of the 1 year. Second, another thing that we haven't talked much about in this bill is that it really is not meant to protect bad actors. And that's the purpose for some of the language that talks about the fact that operators who violate local, state, federal regulations are still fully accountable under those laws and regulations. That's why those laws and regulations exist. This is a very narrow piece of legislation that only limits a common law nuisance doctrine. If there is a liability, if there is a violation of any other public health and safety ordinance that exists, that liability is not preempted by this statute. So I think it's important that we keep that in mind. The other thing that I'll mention is that Arizona would not be unique in adopting language like this. Every state in the nation has some sort of so-called right to farm statute in some way, because it's really universally acknowledged that the state or a state has a reasonable expectation or a reasonable interest in protecting the food supply of its state and in protecting food production that happens within that state. And so the ability to feed and clothe our families is paramount and therefore worthy of protection from something that is unnecessary or frivolous in terms of litigation. So those are the points, the highlights of the bill that I'd like to mention. Again, happy to answer any questions from the committee as they come forward.
Representative Rodriguez.
Thank you. Mr. Mcguire, thank you for coming today. You said that part of the bill's intent is to preempt claims that are filed by people who are so far away that they don't suffer the harm. Did I hear you correctly?
That is, Mr. Chairman, Representative Rodriguez, that is correct.
And so if that is the intent of the bill, then what was the purpose of putting the half-mile radius into it? Because we heard today that Mr. Blackson would not have been included. He would be precluded. If we passed it in its current form, he would be precluded from bringing a claim.
Right, and Representative Dunn, Representative Rodriguez, I believe that that particular radius was based on some information that we have from our producers as well, knowing where their activities and kind of how far they understand their activities to impact. It's also based on several other states. North Carolina is one that comes to mind that has that same 1/2 mile radius. Again, continuing to look at amendment language, but that is the ultimate purpose of that restriction.
Mr. Chair, Ms. Mcguire, and so what I'm hearing is that this was, the advocates of the bill set the 1/2 mile radius. Do you have any other specific information regarding scientific studies or other expert testimony that would substantiate the legitimacy of a 1/2 mile radius?
Chairman Dunn, Representative Rodriguez, no. No expert or scientific testimony to note.
Thank you. Ms. Mcguire, Mr. Chair, you talked about that Arizona would not be unique in passing a statute of this type. Is that correct?
Mr. Chair, Representative Rodriguez, that is correct. All 50 states have some form of a nuisance liability restriction.
And out of those, thank you, Mr. Chair, Ms. Mcguire, out of those 50 states, how many of them have an anti-abrogation clause included in their state constitution?
Mr. Chairman, Representative Rodriguez, in terms of how many have the anti-abrogation clause in their state constitution, I am unaware. I do know that 6 states have upheld the constitutionality of damages restrictions, including punitive damages restrictions, in these types of nuisance liability restrictions.
And Mr. Chair, Ms. Mcguire, now I'm sure you can appreciate the reason why I asked you that question, because in Arizona, our Constitution guarantees us the right to seek redress.
Right.
As I understand it, this would eliminate the ability for someone to seek punitive damages even when the person acts with intent to injure the other person, because you mentioned that this isn't designed to protect bad actors, but punitive damages are entirely designed to punish bad actors. So how do you reconcile those two?
Chairman Dunn and Representative Rodriguez, I would reconcile that by the fact that there are additional health and safety regulations, laws, statutes out there under which an intentionally bad act could be prosecuted.
But would you concede for me that that leaves the property owner, such as Mr. Blackson, without one of the more powerful tools that he has in his toolbox as a citizen seeking redress? The purpose of punitive damages is to punish the wrongdoer, and a person like Mr. Blackson would be left without that tool. So I'm just trying to see if you can explain to us, where's the balance between the large operation's interest in operating and the individual's right to live and enjoy their land peacefully?
Chairman Dunn and Representative Rodriguez, I really do feel that this bill strikes that balance in some of the limitations that it sets in terms of these are rebuttable presumptions. If the operation is acting in such a way that violates a local, state, or federal ordinance, it's no longer, those rebuttable presumptions are no longer applicable. I think that's kind of where that balance is struck.
Mr. Chair, just one more question. Mr. Mcguire, we've heard from staff, and I want to hear this from you. If you're saying that this is a good balance between the two, give me another example of a statute under Arizona law that limits the right to bring a claim in the manner that this bill does.
Chairman Dunn, Representative Rodriguez, like staff, I'm unable to do that at this time, but we'll continue to research and get back to you.
Thank you.
Any more questions for Ms. Mcguire? All right, thanks for being here.
Thank you, Mr. Chairman.
Mr. Chair, next we have Glenn Hickman.
Hello, my name is Glenn Hickman. My office is 6515 South Jackrabbit Trail in Buckeye, Arizona. Our family's been in the egg business now 77 years. My siblings and I are fortunate to be the 3rd generation to run the business and hopefully continue to grow it and pass it on to the next generation. We fully support this bill, and it's already been reported, and I just need to make sure everybody's clear on this. This bill, if passed, would have no bearing whatsoever on the current litigation that is filed against us. What we're trying to do is keep other families that are in business, in agriculture, from going through the same kind of hassle we are. With respect to Mr. Ahrens, I don't know the definition of frivolous either. I will tell you, just three of the claims that come to the top of my mind in this litigation, can't name names. Canine diabetes was brought on by our chicken farm. Someone lived over a mile away. Appendicitis and heart bypass surgery is needed because they're a neighbor to our chicken farm. Our chickens caused an infestation of woodpeckers in one of our neighbors' houses because of our chicken farm. Not sure what the status of frivolous is, but that's what we're dealing with. And that's what we're paying for every single month to defend ourselves. Now, we think we have a great chance to prevail, and we will. But that's the kind of stuff we'd like to try to prevent from future agricultural entities from going through. The reason we're here today is to try to put something in place that would give us, everyone, neighbors, ourselves, clear definition and rules. We specifically are not looking for any kind of get out of jail free card for agriculture. We understand we have to operate within the law. We have to operate responsibly. We have to have good food that we produce. And we have to have a good environment for our workers to live in and work in. Through 77 years, we've had workers' comp claims of all sorts. You know, accidents happen in agriculture. People aren't paying attention. Sometimes that happens. But we've never had and these are people who have been working in barns for 20 years. We've never had an illness or any kind of lung issues from people that work in the barns for 20 years. So we're not trying to run from anything. We're here in front of you today to ask for your support. Be happy to answer any questions.
Any questions? Mr. Rodriguez?
Thank you. Mr. Hickman, thank you for coming down today. You mentioned the woodpeckers. Is that the only claim that the person is making in the lawsuit, is the existence of the woodpecker colony?
The only claim that particular litigant, there's like 30 that are all bunched together.
Okay, so it's part of a larger lawsuit?
Yes.
Okay, thank you. And then the canine diabetes, Mr. Chair, Mr. Hickman, is that the same situation with the claim for canine diabetes, that it's also part of a larger litigation?
Yes, that's correct.
Okay,
Sorry.
thank you. I don't have any other questions.
Mr. Hickman, anybody else have any question? Mr. Hickman, which agencies regulate your business as far as the health and safety stuff, environment, you know?
Chairman Dunn, all of them do. I mean, we've got more agencies that we deal with, from FDA to EPA, local, county, federal, state. We have all kinds of folks. I mean, we run trucks, so we got DOT. I mean, it's never ending.
I don't know, any other questions? Yes, sir. Mr. Pratt.
Mr. Chairman, we've passed a lot of legislation over the years that were geared towards best management practices and for a lot of different kind of operations. But now we're in a different area where people are trying to have frivolous or basically trying to figure out what is the definition of a frivolous lawsuit. Wouldn't there be some conflict if you used best management practices and people came to you and said, I'm going to file a frivolous lawsuit on them? I mean, there doesn't seem, there seems to be a disconnect there to me.
Chairman Dunn, Representative Pratt, I'm not the attorney, but I think what we're supporting is only if you are operating correctly do you get any protection from the nuisance lawsuits that we're suffering. if we're not operating within our air permit or our zoning or anything in between, we would not have that protection, or any agricultural entity would not have that protection. So we first have to be obeying all the laws first.
Mr. Chair, to Mr. Pratt's point.
Yeah, go ahead.
Go right ahead.
Oh,
Go ahead, Mr. Rodriguez.
Representative Pratt, if the question is you're asking how can we tell a nuisance lawsuit from one that isn't a nuisance, that is really kind of in the eye of the beholder sometimes. It is determined after both parties have a chance to submit their claims, and then there'll be various motions to try to dismiss the case if they either can't state a cognizable claim on the law, or they can't show that, for example, there are no facts to substantiate what they're saying. Then that can be dismissed, and then that can be described as a frivolous lawsuit.
To that point, wouldn't that be a problem for a mitigation of two parties instead of a lawsuit or a frivolous lawsuit?
Mr. Rodriguez.
Mr. Chair, Representative Pratt, most counties have mediation programs where the parties, I think all counties actually have mediation or arbitration. The problem is that this claim is going to be large enough monetarily so that it falls outside of the eligibility for an arbitration or a mediation program. So if your question is there a way that we can get to this issue without affecting someone's right to bring a lawsuit? Perhaps something along the lines of a mandatory mediation for these types of claims, no matter their size, might be a reasonable alternative that would still allow them to file a claim if they were not able to resolve it through a mediation.
To your point, my only comment or problem is with this is when you have a person that is doing things by the book, if you will, or by best management practices, and they are being hounded by someone else, there's a breakdown there somehow.
Mr. Chair, Representative Pratt, I would agree with you. The problem is we run into situations such as Mr. Blackson's where it's just good faith disputes between folks.
We've got a few more testimonies still. Any more questions for Mr. Hickman? Thank you for being here.
Thank you.
Mr. Chair, we have Patrick Bray.
Mr. Chairman, members of the committee, for the record, my name is Patrick Bray, representing the Arizona Farm and Ranch Group. I think you've heard a lot of testimony here. Bottom line is, look, we looked at the nuisance laws that we have on the books today. We've seen what's occurred. We believe that based on COVID and some issues that we had there, we thought, you know what, we need to look at how can we make sure that we have a secure food supply for everyone in Arizona. And we thought, okay, let's start digging into those protections. It's morphed over the years. Ms. Mcguire has talked about it, how every state has some sort of nuisance lawsuits on the books. They have been challenged. They have stood up to courts, and they've kept them in place. And so we looked at those that have been challenged, and we started putting those into statute here in Arizona. We hear the comments that people are making. There are a group of stakeholders working through that. To Mr. Aaron's comments, we're not purposely holding out anybody from the room, but we are trying to get some things nailed down before we start looking at some of those other issues. But I do want to address some of the issues. We have conceded on the 1 year. We understand the concern there. And to flip that, I think maybe this does address some other stuff in the rebuttable presumption. We say that the ag operation also has to conform to generally accepted agricultural practices and cannot have violated state, federal, or local regulations in the last 3 years. So it actually lowers that bar for the plaintiff because there's a wider window there that we're discussing. Also, people talked about increasing the size of the operation or changing the operation. We went in and changed a section there that said you basically can't go from a cotton farm to a dairy farm or some other facility if it requires a change in permit, zoning, anything like that. That would say, okay, it's a new time clock at that point, because that is a complete change of operations, plus they're going to have to get different permits and so on and so forth. So we are addressing a couple, trying to address as much as possible at this point in time. We are talking with cities and towns as well. I definitely don't believe that you'll see the language that is in the bill currently today. We're looking at possibly just limiting them doing ag nuisance ordinances moving forward and narrowing that to ag nuisances related to ag operations. So we understand the 40-acre ranchette situation and all that. We don't want to get in the way of cities and towns doing that, but we do want to narrow that scope for these types of lawsuits that some people may consider frivolous. So with that, I'd be happy to take any questions.
Any questions for Mr. Bray? Nothing, Mr. Rodriguez?
No, sir. Thank you.
Patrick, so kind of talk a little bit about like how you get a confined animal feeding operation if you're wanting to convert your alfalfa farm to a CAFO.
Well, the gentleman before me is probably has much more knowledge about it, but bottom line is you're going to have to go through all the processes that are put in place through DEQ to get a general air permit. You're probably going to have some additional water permits to make sure that the aquifer is protected. Not to mention, the zoning cases that you're going to have to go through. I mean, it's not like overnight you decide I'm going to quit growing alfalfa and I'm going to start growing, or put 1,000 head of feeder steers or 1,000 head dairy on this property. Now you're going to have to go through all the hoops and regulations, which opens it up to that public comment. Hopefully allows those things to come forward, and hopefully any disputes beforehand are worked out before we ever get to the courts.
Thank you. Any more questions for Mr. Bray? Thank you for being here.
Thank you.
Mr. Chair, I have 3 online: Sandy Barr, Tom Savage, and Mike Worth. And perhaps we can bring each of them in and do them in that order.
Go ahead, Sandy. Ms. Barr? Go ahead, Ms. Barr.
Oh, sorry, there's that delay and I was hopping over, so I apologize, Mr. Chairman, members of the committee. I'm Sandy Barr. I'm the chapter director for Sierra Club's Grand Canyon chapter. That's the Arizona chapter. And we are opposed to House Bill 2372. I think what you've heard from the people who have testified is this is a bill that is clearly not ready for prime time, even if it was good public policy, and we believe it is not. It significantly limits the ability to bring nuisance actions and, of course, preempts local government from acting to protect the people in its community. The bill is clearly in response to complaints and actions against large concentrated animal feeding operations, including one in our county, and we've heard about that. They have significant smell, noise, excessive lighting, and other issues associated with them. But I also wanted to point out that this is a bill that is making the rounds across the country after showing up as model legislation from the American Legislative Exchange Council and as part of the so-called right to farm effort. Many have called this the right to harm instead, and we think that is a more accurate term for it. As is, again, often the case, ALEC legislation doesn't translate well into good public policy, including in Arizona. These measures are written for big industrial agriculture to the detriment of communities and smaller farmers. Having an agricultural operation does not preclude one from requirements to be a good neighbor. The bill encourages irresponsible and unneighborly operations by agricultural entities, especially CAFOs, as you've heard about, with all the pollution, air and water pollution, odor issues, noise, and other impacts. I wanted to point out that we already do have significant protections in statute related to agricultural operations. And 112, and I'll let you read that for yourself. So there's already significant protections included if they're acting reasonably. And if they're acting reasonably, then it would limit a nuisance action, or operating reasonably. The bill is not only unneighborly, it is likely unconstitutional, as you've heard from others, and violates the property rights of the neighbors, then their right to enjoy and use their property. It is also, yeah, someone else covered that, so I'm not going to go into that. But nuisance laws such as what is being proposed in 2372 do not benefit the family farmer. Peer-reviewed research shows that large-scale agribusiness interests primarily benefit from these laws. These large industrial agricultural operations externalize their pollution costs and take away the property rights of their neighbors. So we also, I wanted to point out that this is not about coming to the nuisance, as was said. What this would allow is for a significant nuisance to come to people and leave them with no redress, and that's just wrong. We encourage you to reject this bill, and if you're going to move forward with a stakeholder process, to include those most affected by these facilities as part of the process. Thank you, and I'd be happy to answer any questions.
Thank you. Any questions for Ms. Barr? Thank you for your testimony.
Thank you.
Mr. Chair, next we have Tom Savage.
Thank you. Good afternoon, Mr. Chair, members. Tom Savage on behalf of the League of Arizona Cities and Towns. At this time, we are opposed to House Bill 2372 due to the preemption of local nuisance ordinances, but we appreciate the recent discussions we've had on our concerns with the bill. I just first start off by saying, we believe that agriculture operations are vital to our state and our cities and towns. They create many jobs and contribute to our local and state economy. And further, we believe that state and local laws should provide reasonable protections for the continuity of this industry. However, House Bill 2372 and its companion in the Senate will severely limit the ability to address public health and safety nuisances caused by farming and related activities on properties where farming is an allowed use within city or town limits. Since nuisance action isn't defined in the legislation and only a complainant who has real property near the farmland can file an action, a city or town would no longer be able to address non-agriculture nuisance issues on farmland or an agriculture operation unless it happened to have real property impacted by the nuisance. And I just want to provide a few examples of the type of nuisances we're talking about. So this can include large-scale and unsafe accumulations of mulch, trash, debris, and combustible materials on these types of use of properties that pose substantial threats to neighboring properties. This could include buildings with structural issues that pose danger to nearby properties, accumulation of pests or vermin, or even drainage issues that impact adjacent properties. The preemption that's included in the bill creates the potential for serious public nuisances to exist on agriculture farming use properties with little ability for cities and towns to take corrective action in a timely manner to preserve and protect the health, welfare, and property of surrounding residents. We understand that there are amendments coming forth. We look forward to further discussions on this and addressing these issues in forthcoming stakeholder meetings. We would very much appreciate the opportunity to be able to sit in the room and discuss these issues with the stakeholders. But for now, we are in opposition to 2372 and happy to answer any questions from the committee members.
Any questions? All right, thank you for being here.
Thank you, Mr. Chair.
Is there anybody else? Is there any other questions or discussion? We'll get some protocol question answered. Paul's finding out. Okay. Mr. Vice Chairman, move the bill.
Mr. Chair, I move that House Bill 2372 be given a due pass recommendation.
Committee, member, you've heard the motion. Secretary will call the roll.
Representative Barton,
May I explain my vote?
Please.
Okay, I am glad to hear that we're working on some amendments. That's a good thing. And appreciate all the testimony that we've had today. Been taking some notes, so that's a good thing. But I'm going to vote aye so we can still work on it, move it forward, and come to some resolution on the situation, because we do need to do this.
Representative Blackwater Nygren,
Gonna pass.
Representative Cook, Representative D'Alessandro,
No.
Representative Epstein,
No.
Representative Griffin,
Aye.
Representative Pratt,
Aye.
Representative Rodriguez,
No.
Representative Sierra,
Mr. Chair, may I explain my vote?
Please.
You know, I want to thank the Hickmans for coming on out here. I got to admit, I've worked with your team. We've fed hungry people, and you've always been there when we needed you. And you know, I just got to say that I came in here with an open mind, and Mr. Blackson, your testimony just really struck at me in terms of you know, what it is we're doing here. And first and foremost, it's got to protect those people that you know, don't have as big a voice as others. So I want to thank you for speaking up. And you know, I just find a lot of the elements of here problematic, and I think I'd like to see it being worked on. But just for right now, I've got to be a no.
Representative Blackwater Nygren,
No.
Representative Cook,
Aye.
Representative Vice Chairman John,
Aye.
Chairman Dunn.
I'll explain my vote. We are committed to working on these amendments. We'll be holding them before the floor process to make sure we work. It doesn't mean we're going to maybe get them all done, but we're going to make sure we work on with the people that are at the table. And so this is not to stop the bad actors. This is just to stop the frivolous nuisance lawsuits. And with that, I vote aye. Members, by your vote of 6 ayes, 5 nays, everybody present, you have given House Bill 2372 a due pass recommendation. Next item on the agenda.